Thank you for that introduction. Hi, everyone. This is Adrian Adams, and we're going to be looking at the new laws affecting associations. There was a lot of legislation this year, and I'm going to share my screen so we can take a look at that. Okay, as you can see, we're going to be looking at a number of bills, and we'll start with the first one being emotional support of animals. This is actually a very good bill. As many associations have experienced, there's been a lot of abuse of the emotional support animal laws or requirements. So that basically if anybody wanted a second dog or a third dog, all they had to do was claim that it was for their emotional support. And what the legislature did was they recognized the abuse that was occurring. And so they passed this at AB 468, which made a number of changes, which were all good changes. First, the healthcare provider must be licensed and, importantly, have at least a 30-day relationship with the patient and give a complete clinical evaluation of the patient. What that does is it stops all of these internet mills where someone would go online and they would fill out a little form and claim to be that they needed emotional support, and you'd have a person on the other end who could be, for all we knew, a psychic that would look into the crystal ball and say, yes, you need emotional support animal, and give them a certificate, and the associations had to honor it. So now that all goes, so that now they have to see a real healthcare provider. They have to have that has to be licensed and have to have known them for at least 30 days. And the other thing that it does is it puts restrictions on the sale of service animals, the sale of ID tags, the sale of vests. So it puts an onus on them to make sure that they're doing this properly. And so this was actually something that we've been looking forward to and hoping legislature would do at some point, and they've finally done it. Next one we're going to look at are elections by acclamation. This is another one that associations have been wanting for a long time, and that is when there are, for example, 3 seats open for election and only 3 persons running for that, 3 nominations, associations still had to go through the expense of preparing ballots, sending them out to the members, hiring an inspector of elections, and counting ballots where they already knew what it was going to be. So the legislature again stepped in and said that if the following conditions exist, the seats are uncontested, meaning there's three open seats and there's 3 or fewer candidates, and association has held an election in the prior 3 years, and then they have to give notices. So there has to be a 90-day notice prior to the deadline for nominations that they give the membership notice of the election procedures and the number of open seats. And then there's a requirement that they give an additional reminder notice 30 days prior to the deadline, and then list those nominees that have raised their hand and said, I'm willing to run for the board. Now, so this is actually a good change in the law. The downside is it now extends elections to a 6-month election cycle because of the extra notice period for letting people know on, that there may be an election by acclamation, giving the notice of the nomination procedures and so on. So this is going to require another change in election rules for everyone, and they need to add this into their election rules. And they don't have to do elections by acclamation, but so many of them have difficulty finding nominees that they have difficulty in actually filling seats. And so this would be actually a nice process that would eliminate the expense of having to go through sending out ballots to everybody. Next one we're going to look at are election cleanups. The SB 323 from a couple of years ago, 2 or 3 years ago, made a mess of the election process and inadvertently knocked out term limits. What this does, this bill made it clear that term limits are allowed. And so for those associations that want term limits, they can now start using them again. For those who've never had them, they can adopt them. So you can actually put in, where there's actually associations that don't have a problem finding nominees, this helps to make sure that there's going to be turnover on the board. The other thing that they added was that the nominees, before if they entered into an election or into a payment plan, let's say that they were delinquent in their assessments, they still qualified for elected to the board of directors if they entered into a payment plan. The problem was that's all it said. All they had to do was enter it. They didn't have to comply with it. They didn't have to make the payments. They just had to enter into a payment plan. Well, this makes it clear now that the nominee has to also comply with the payment plan. Next thing it did is it requires that when you put out the candidates list, so those who have nominated themselves or been nominated to run for the board, the candidate list now must include the address of the candidates, so their name and address. Another thing that it corrected was it did never mention in SB 323 whether appointed directors had to fulfill the same qualifications as candidates. So it clarified that by saying, yes, they do. So if the board has a vacancy and they want to fill that vacancy, the candidate, the person that they appoint, must be an owner, and then if there are other requirements that are in the election rules, they must meet those in order to be appointed to the board. And then finally, it eliminates pre-ballot notice requirements for non-director elections. The next change that they made, another cleanup, was that SB 323 had also messed up how recall elections were handled. Because prior to this change, recalls had to be done within 35 to 90 days. Yet the election process for a new director took up to 120 days. And so that created a gap between a recall and the seating of new directors. And the problem is that you can't have a gap under the corporation's code. You have to have a board of directors. So what it did was it meant that the recalled directors stayed in place until new directors could be elected. Well, this cleanup now changes it. The waiting period or the period for which the recall occurs between 35 and 90 days is now extended from 35 to 150 days, so that it overlaps with the election of new directors, so that both can be done simultaneously now with this new election cleanup. Next one is AB 611, which is called Safe at Home. What this does is it requires, upon request of an owner, the associations must use the address designated by the Secretary of State as the person's address for the membership list and for HOA communications. Now, what this is for is to protect those who are victims of domestic violence, sexual assault, stalking, human trafficking, and so on. The Secretary of State becomes the agent of service process and keeps and also designates the address that would be used for communicating with this person so that they can be safe. In other words, the person who might be stalking them won't know their real home address. And what the association is required to do, not only for the membership list, but also to withhold or redact information from the mailbox, directories, electronic keyboards or keypads, unit property numbers, and so on. So in other words, to protect that individual so that whoever that they are trying to keep safe from cannot find them. The next one is a change or a correction, an update to the financial security requirements of the Davis-Stirling Act. And this is AB 1101. And what it does is it changes the threshold. So the threshold for written approval, in other words, the board has to approve any kinds of transfers of funds, so that now it's a percentage of the estimated budget income rather than previously the amount that would be in the funds. So which would change from month to month or even week to week. And so establishing a 5% or 10% number, whenever you try to establish that, it's difficult because it keeps changing. So here what they did was they set a flat fee of either $5,000 or 5% of the estimated budget income for the year to 50 units or less, and 10,000 or 5% if it's 51 units or more. And then it allows managers to deposit HOA funds in credit union accounts, which is a plus. It gives a little more flexibility here to associations. But those accounts must be protected by the National Credit Union Insurance Fund. So as long as they're insured, you can now put them into credit union accounts. Another thing it did was that management companies cannot commingle HOA funds with their own money. And you'd think that would be obvious, but they wanted to make sure it was clear that there can be no commingling of funds. It needs to be into a separate account, so designated for the association. Another thing that they clarified was the fidelity bond. Previously, they required associations to carry fidelity bonds, but most insurance companies didn't issue bonds, they issued crime insurance. So they defined fidelity bond now to mean crime insurance, employee dishonesty coverage, a fidelity bond, or an equivalent, which is good. So now it's clear that it makes it a little easier for them to get the insurance that they need. And they added that it must also cover computer fraud and funds transfer fraud. So these are all good changes that help to ensure or protect the association's funds, which is important. So because, as we know, fraud does occur from time to time, and you want to make sure that you can insure against that. Another is change in the law is AB 1124, dealing with solar energy systems. And previously, it required that the associations had to allow panels on buildings. Well, sometimes owners wanted to or needed to put them on the ground, especially in planned developments, where in their backyard is a better spot to put it for catching the sun rather than putting it on their roof. And so this now allows the requirement, allows them the flexibility of being able to put it on a building or on the ground. It also includes solar racking, solar mounts, and elevated solar support structures, whether they be on the ground or on a building. So those are now, again, the idea is to make it easier for owners to install solar energy systems in order to take some of the pressure off the grid, the electric grid. Another change is AB 1466, discriminatory requirements. And as most of you know, the associations are required to put a cover page on their CC&Rs, which states that, if the document contains any restriction based on race, color, religion, and so on, that it's unenforceable. Well, they've added now age, so based on age, race, color, religion, and etc. And that, now you would think, okay, well, what about age-restricted or senior communities? There's an exception for those. So existing senior communities, age-restricted 55-plus communities are not impacted by this, but everybody else is. So it's a simple change of adding the word age in there and putting that in, recording it against the CC&Rs. The other thing that the bill does is it makes it easier to eliminate discriminatory language, so that if a real estate broker were to see that there's restrictive language in there, that they can step in and make sure that that language is removed. The next one is AB 1584, dealing with rent restrictions. Those went into effect last year, and what the legislature did was require that associations amend their documents to conform to the legislature's rent restriction standards. And basically what it did was, if you had a rental cap of 10%, the legislature said you can no longer use that 10%. It must be 25% or larger. So you can't have anything less than 25% as a rental cap. And the other thing was that many associations would have lease requirements, that leases be no less than 6 months or be no less than 1 year. The legislature changed that to 30 days, so that you cannot have in your documents any requirement greater than 30 days for leases. So lease terms, in order to comply, the associations were required to almost immediately amend their documents. And that was a problem, because taking it to the membership, it just takes too long. So one of the things that they did was they extended this now to July 1 of next year, 2022. And we were, our firm was advising clients that the board could do this on their own, that it didn't have to go to the membership to take a vote. And one of the things that the legislature did was to clarify that and to say, yes, boards can do this on their own. They don't have to go to a vote of the members. Because as most of you know, have experienced, that voter apathy alone makes it almost impossible to pass anything. And so they're authorizing boards now to make these amendments, these changes on their own. And this is provided that they already have existing restrictions in place. So if they have a minimum lease requirement, 6 months, a year, the board can on their own change it to 30 days. If they have a rental cap, existing rental cap, it would be 10, 15, 20%. Board, without a vote of the membership, can change it to 25. But what they have to do is give the membership 28-day notice of their intended changes to the CC&Rs, so that they can consider any input from the membership. And the other thing is to clarify that if there is no existing rental cap in their CC&Rs at all, and the board wants to put one in to comply with the 25% requirement, this has to go to a vote of the members. Because the requirement is not that they have the 25% cap, but that if they have an existing cap, they conform to it. So if they want to add a cap that doesn't exist, the board cannot do this on their own. It must go to a membership vote. Next one is SB 9, lot splitting, which has caused a great deal of concern for planned developments, and that is single-family lots with a single-family house on it can be split, and you can have a duplex on a single-family lot. One of the things that the associations were concerned about was how that would impact membership, or because if you're adding or splitting the lot and adding now another unit on, you're now adding members. What does that do with assessments? How's it, there's just all kinds of legal impacts that could be foreseen if lot splitting is allowed in common interest developments. So Senator Tony Atkins wrote a letter making it clear that her bill does not affect HOAs. We're hoping that that is indeed the case. We won't actually know until someone were to challenge it and it goes to court, or the legislature were to add some kind of qualifying language to it. But right now, we just have her letter saying that it does not apply to HOAs, and we're hoping that that's the case. Okay, another change is SB 391. This bill dealt with virtual meetings. The pandemic forced And under emergency orders from the state, it stopped all meetings. And so people couldn't get together and meet. So association board meetings, association annual meetings could not be held physically in the same place. And that led to Zoom meetings. And across the state, everybody started using Zoom meetings. And so that they found that they could do it, it could be done. People became adept at it. Associations now use it and may continue to use it beyond the pandemic. But one of the things that's required once the emergency is over is they have to have a physical location where people can go if they want to. Well, what the legislature did was, for future emergencies, declared emergencies, such as the Paradise fires in Northern California that basically wiped out all structures. In an association, they had nowhere to physically meet. And everybody was scattered all over in the state and out of the state. And the only way that they could really meet effectively would be to meet virtually. So what this does is it eliminates the requirement for physical location in the event of a declared emergency that would apply. And it also requires that the association give clear instructions for participants on how they can participate in the meetings. It requires a phone and email address for a tech who can assist those who are having difficulty logging into the meeting or participating in the meeting. And it requires a roll call vote by the board when they vote on issues, because not all meetings would be held by video conference. It allows for conference calls and video or conference phones, so that if you have people listening in over the phone and participating in that way, they won't always know how everybody voted. And so roll call votes would be required so that they can hear each of the directors and how they're voting on a particular issue. And then finally, if it's an annual meeting where there's an election and a counting of ballots, that must be held by video so that people can see the meeting, and it's required that the camera be pointed at the inspector of elections so that they can see the inspector counting the ballots and tabulating votes. So this is another plus, another good piece of legislation for associations. Let's go to the next bill, SB 392, dealing with document deliveries. And as many associations have been trying to move more into emails, which is more convenient and less expensive than using first-class mail, this bill states that members can select a preferred delivery method, because a lot of homeowners also prefer to have things delivered by the association via email. And so they can now select, I want things delivered to me by first-class mail, I want it by email, or I want it by both. And then starting in 2023, the associations must deliver the documents by the preferred method. So that's going to require some changes by many management companies, in that they must be able to keep track of what members have selected as their preferred method of delivery. And then they must try an alternative method if the email bounces. So this is going to be a little complicated for management companies to make these adjustments. But once it's done, it will be easier for members to select how they want information to be delivered to them. And then the other thing is that general delivery now can be done by posting on a website. A lot of times, well, prior to this, they would be posting notices of board meetings on an elevator or a board out by the gate, or some prominent place. But not everybody would see that. And so now this makes it easier for everyone to simply log in and look at the website to see notices being posted there. So this is another plus, another good piece of legislation for associations. Next one is SB 607, dealing with balcony inspections. And this is actually elevated structures. But everybody refers to it as balcony inspections. And prior to this change, the inspector hired by the association to inspect the balconies was prohibited from making any repairs to the balconies. This eliminates that restriction now, so that the company that's doing the inspections can also, if the board wants them to, make the replacements. Or the board still has the option of choosing another party to come in and make the repairs. So this gives a little more flexibility to associations, because sometimes it's difficult to find an inspector come in and then a separate company where they might, some companies have both in-house. They have an engineer or an architect in-house, and they can also perform the repairs. So again, a little more flexibility for associations. Okay, so this it's just basically a broad overview of the bills. You can find them in more detail on our websites. If you go to Davis-Stirling.com, we have under legal new laws that you can go in and you can actually click on, you can read the summaries of the new laws. You can also click on and read the bills and see the actual changes in the bills. They'll take you straight to each of the individual bills so you can read them for yourselves. All right, thank you everyone for your time, for attending this presentation put on by HOA organizers. They're a great management company. They put this on every year for your benefit. So if you have any questions, please feel free to send them through HOA organizers or through our website at Davis-Stirling.com. Thank you.
Davis-Stirling is California's premier law firm exclusively representing common interest developments. We provide general counsel and litigation services to a diverse portfolio of clients, including both homeowner and commercial associations. For the past 20 years, Davis-Stirling has advised boards of directors in the effective governance of associations and advised on the implementation of strategic plans that reduce their liability risks. Davis-Stirling is well known for its weekly newsletter and award-winning website, Davis-Stirling.com. The website and the newsletter reflect the firm's commitment to education and is the #1 relied upon reference for the interpretation of the Davis-Stirling Act.